Good afternoon, everybody. Thank you for joining this session on interim relief. My name's Catherine Urquhart. My colleague Sam Healy, we're both barristers at 42 BR, 42 Bedford Row, as we used to be, in the employment team. This is the first session in our latest employment law series, leading up to Christmas, but the sessions from January to July this year can be found on our website. If you've got questions during this session, please put them in the Q&A box and we'll try to pick up as many as possible at the end of this session or follow up via email. And if you're watching the recording of this at a later date, please send your questions to events@42br.com. An email containing the recording, the slides and a feedback form will be circulated over the next few days.
Thanks,
Right.
Kath. So we're going to start off with an introduction to the weird and wonderful world of interim relief. So perhaps, Kath, you can kick us off with a brief intro to this particular area of employment law.
Yes, thank you, Sam. What is interim relief? And it is a rather unusual beast, as you say, because it's a mechanism whereby an employee who's been dismissed in some situations can get an order from the tribunal that the employment relationship has to continue. In other words, they either keep going in their job or a similar job through re-engagement, or they get their salary until the final hearing of the claim, or perhaps until the matter is settled. I'd say it's the closest thing to an injunction that you get in the employment tribunal. It's unusual in that the general principle in contract law is that the parties aren't obliged to contract with each other if they don't want to, but here they're being forced to in these unusual circumstances. And it comes out of trade union law in the 70s. And there's a case of Bombardier Aerospace and McConnell from 2008, which talks a bit about the history of it, which if you're an interim relief nerd, you might be interested in. But it says that an application for interim relief is intended to head off industrial trouble before it begins, or at least before it becomes too serious, by allowing an employment tribunal to give a preliminary ruling at an emergency hearing. That's talking about the origins of interim relief in the 1970s when it first came in. And as you may have gathered, that was really in relation to trade union membership or activities. But over time, it's expanded. And typically, the sort of situations where you encounter it now are either in relation to trade union activities or in relation to whistleblowing claims, where perhaps somebody's been dismissed and they might not have 2 years service to bring in a claim of ordinary unfair dismissal. And I think sort of sitting back and looking at the types of claims where you can apply for interim relief, there are things such as trade union activities and whistleblowing, where there's a wider public interest in the matter under consideration. So in other words, that makes it different to a straightforward private claim of ordinary unfair dismissal. So I'd say there's a theme there in terms of the types of claim that you can bring. But I'm slightly encroaching on your patch now, Sam, because I think you're going to talk to us now about the types of dismissal that would allow an ex-employee to bring a claim for interim relief.
Yeah, thanks, Kath. So I'll drill down in just a moment into the detail on the types of specific complaints that can ground an application for interim relief. There's sort of headlines on the slide you've got at the moment, just those last 2 bullet points. So bear in mind, if you're not already aware, it's not available in cases of so-called ordinary unfair dismissal or a discriminatory dismissal. So a case where you're saying you've been dismissed and it amounts to discrimination on the basis of a protected characteristic. And the general rule is, which we'll look into in a bit more detail, or the general sort of rule of thumb rather, is that it's very hard to persuade a tribunal to grant interim relief. Not impossible, of course, it does happen, but there is quite a steep curve that the applicant claimant's got to overcome. So looking now then at the sort of the gateways to the application, a lot of these are found in the Employment Rights Act 1996. That's sort of like the first sort of slice of legislation that you would need to look at to see whether your particular case might lead to a application for interim relief. And and the applicant will have to bring themselves within one of these categories by persuading the tribunal at the interim relief hearing that the reason or the principal reason for the dismissal is one of these protected sort of provisions, as it were. So going through those, some of these are more commonly encountered than others. So first of all, there's having been designated by the employer to carry out health and safety duties. So if you are an employee that's been given that sort of role to do, and you're alleging that the dismissal flows from that, then that could be grounds for claiming interim relief. And then sort of allied to that, there's the provision that if you are carrying out your functions as a health and safety rep, and that's the reason or the trigger for the dismissal, then that could also ground the application. Important to note that dismissals which are alleged to arise out of health and safety matters, as set out in section 100, subsection 1 of the ERA, such as refusing to return to the workplace in circumstances of danger, aren't caught. And that's actually quite common, that you might get a claimant that's saying, I've flagged up a health and safety issue at work, I'm not happy, I don't feel safe at work, and I'm alleging that I've been dismissed because of that. Well, that particular situation wouldn't be caught by the interim relief provisions. Contrast that with if you've got a claimant who's actually a health and safety rep or carrying out his health and safety duties. So a few more sort of niche areas, if you like, which are included within section 101A and section 102 of the ERA are performing functions as an employee rep in relation to the working time legislation, and also as a trustee of performing functions as a trustee of a relevant occupational pension scheme. So again, these are quite narrow gateways, as it were, which aren't encountered that often on the facts. And one final one, before I come on to protected disclosures, performing certain functions as an employee rep or candidate to be such a rep in the context of collective redundancy or 2P. So if you've got a sort of collective situation where there's a pending election for representatives in a collective redundancy exercise or a 2P exercise, then presumably that is a situation which will be caught by this, and the employee could allege that they've been selected for dismissal because of that function they're going to perform. Now, all of those are a bit, as I say, somewhat sort of esoteric, if you like. They don't always crop up in practice that often. The one which we do find all the time cropping up is if the claimant is making a protected disclosure, or they allege they've made a protected disclosure. That's under section 103A of the ERA. Now that's the one you'll probably find in practice the most. Obviously, the claimant may well not have 2 years service, and they bring in a claim of automatic unfair dismissal on the grounds of whistleblowing. Then it's quite often that they'll tag on to that an application for interim relief. Now, what I've gone on to now on this slide, however, is the other sort of tranche of legislation, which is a gateway. Other than the ERA, it's Tallrika 1992. And this comes back really to what Kath was mentioning earlier, that the foundations of the application for interim relief is really in trade union legislation. And the 92 Act sets out a number of situations in which an employee can claim interim relief on certain grounds. The first one you've got there is if, for example, they are alleging that the dismissal was unfair under section 152. And that's actually probably one of the more important ones, because that's going to cover trade union membership and activities. So say, for example, you've got an employee who is going about their trade union activities, perhaps representing a member at hearings, perhaps campaigning for things within the workplace, and then they are subject to a disciplinary process, which they will say came out of the blue, and it has a a timing or a coincidental timing with their involvement in trade union activities, then that's a classic example of where you'll get a claimant looking to rely upon this ground. There are others under the sort of trade union legislation, which you can dig into if you have one of those crop up. For example, if you have a claimant who is alleging that their dismissal is in connection with the process for trade union recognition or collective bargaining or balloting, then that would also potentially be a ground for interim relief. Now, it's probably important to bear in mind that if you are dealing with a trade union situation and a Section 152 claim, you'll need the certificate from the trade union official, which essentially is there as a kind of safety valve, if you like. So the tribunal has some assurance that an independent person, a trade union official, has looked at the case and has decided that there is at least a prima facie case that their member has been subjected to a dismissal on the grounds of trade union activity.
Yep.
Just one, let me just deal with this one final point in relation to when you're looking at any interim relief case. It is really important to look at the statute, where look at either the ERA or Torica, to be able to make a clear judgment on whether your particular complaint is caught by the legislation, because there's some that are not. And one example is if the claimant says they were selected for redundancy because they made a protected disclosure, then because of the way the legislation is worded, Section 105(6)(a) of the ERA, that would not be a situation which would fall within the gateway provisions. I mean, there's reasons for that. The selection process might make a redundancy unfair, but the selection itself is not the reason for the dismissal. And as we know, the interim relief application is focused on the reason for dismissal.
So you mentioned discrimination a few minutes ago, Sam, and there was a case a couple of years ago in the Court of Appeal on the subject of whether, if you bring a claim of a discriminatory dismissal or a dismissal because you've been victimised, can you claim interim relief? And you can sort of see the tribunal shuddering at the prospect, can't you? Because if that was allowed, surely there'd be so many more claims. Now, obviously, that's not the reason that it didn't get through, I'm sure, but might have been a factor in their thinking. The claimant here brought a claim saying that the lack of availability for interim relief in discrimination cases was unlawful discrimination in breach of their Article 14 rights, which is your right not to be discriminated on against on the grounds of a protected characteristic. So it went up to the Court of Appeal, which dismissed it, and they found that they weighed up the different types of remedy. They said that there's no less favourable treatment because the procedural and remedy advantages of discrimination and victimisation claims outweigh the benefit to the right of a claim in interim relief. So, for example, with discrimination claims, you've got a bit more discretion over time limits, a more favourable burden of proof, the availability of an injury to feelings award, and the potential for third-party liability, which doesn't apply in whistleblower claims. So that didn't succeed, but I slightly wonder if they were thinking, crikey, if we allow it for discrimination, we're going to have a real problem with managing the tribunal.
The floodgates would open because one of the things we'll come on to is how quickly you have to deal with interim relief applications. So obviously the sort of higher courts were no doubt alive to the fact that this could lead to a deluge of interim relief applications. So an ingenious attempt, perhaps, to try and extend the scope of these provisions, but not one that successful.
Not one that succeeded. So just looking at this slide, can you claim? We've got a few more jurisdictional points to think about before, if you're from the claimant's point of view, before you can put your interim application in. And straightforwardly, you must be an employee. Now, if employee status is in doubt here, that's one of the things you will have to prove at this interim relief hearing, that to the high standard that we'll come to in a minute, that you're likely to succeed in showing you're an employee. So if there's a dispute over employee status, that's something you'll need to address. So you need to be an employee. You do not need 2 years service, however, and you do not need to have gone through ACAS early conciliation. There's a box on the ET1, I'm sure you've seen, I think it's box 2.3, which you can tick if you're bringing an interim relief application. And the reason you don't need to go through ACAS conciliation is primarily because you've only got 7 days to bring your interim relief claim, 7 days from the effective date of termination, 7 days from the dismissal. So it's a very short deadline. It's not possible to extend it. There's no provision for that in the statute. So if you miss it, that's it. You've got 7 days and no more. So let's say you've got your right sort of gateway provision. You've got you're an employee. You put your claim in 7 days. What are you going to do next, Sam? How are you going to persuade the judge? What's the case law on persuading the judge that you're going to succeed at trial?
Thanks, Kath. So we'll come on to that. Just before I do, really important point which Kath just mentioned is when you're looking at the jurisdiction, everything's in issue in terms of if you're resisting this claim, first thing to look at is this a claimant who actually is an employee? Lots of cases where the claimant's only going to be a worker, might be an agency situation, for example. And that may well be a knockout blow for the interim relief application, because if it's absolutely clear that they are not an employee, there's no contract of employment, and they've been sort of allocated to the respondent via some employment agency or some similar setup, then that could be an easy way to, from the respondent's perspective, to dispose of the application before you even get to the question of what was the reason for dismissal.
Yeah, good point.
But let's look at what is the sort of law that's going to apply at the hearing? The leading case is still one from the late 70s, which is the Taplin case you've got on the slide there, which uses this sort of great real sort of common sense approach. Does it have a pretty good chance? Does the claimant have a pretty good chance of establishing they were dismissed for the prohibited reason at the final hearing? So it's a question of the judge looking at all the evidence that's available at the interim relief application and pushing their chair back metaphorically and asking, has the claimant got a pretty good chance of proving that they were dismissed because of whistleblowing, because of trade union activity, whatever.
How does that compare to the hurdle that you overcome at the final hearing?
Yeah, so this is a much harder hurdle to overcome. Yeah. It's not the balance of probabilities. It's not like a kind of a mini trial using that test. It's a much sort of tougher test than that the claimant's got to overcome. It's almost a bit like in the county court or high court jurisdiction, the sort of real prospect of success type approach. So more than 51%. And it's been looked at and there's a number of cases which have kind of sort of expanded upon the approach in Taplin. So you've got there the Derby Daily Telegraph case from 1991. Does the claimant's case look like a winner?
Very judicial language there.
Yeah, lovely, which is a sort of similar sort of rough and ready approach. And that's what these applications are. They are rather rough and ready. And as we just mentioned, is about the test being stricter than at the final hearing. In that Dan Pat and University of Bath case, it was emphasised there that there's policy reasons for setting the test comparatively higher. And you might think, well, what is that? Why should it be harder at the interim relief hearing than what you're going to have to overcome at the final hearing?
Yep.
Well, it's because of the potential sort of consequences for the respondent if the interim relief application succeeds. Effectively, it's an injunction in all but word, in all but name rather, saying that the employer has to continue with this employment relationship and continue to pay the employee. So important to, obviously, as this side makes clear, that the burden is upon the claimant. They will have to do all the running, as it were, and they'll have to convince the tribunal to the standard as set out in Taplin. And it's every element of the claim. It's, as I indicated earlier, employee status, as well as, for example, the reason for dismissal. If there's an issue about other key components, then they will have to be established as well. For example, the identity of the respondent, for example, that it was in fact the employer.
Yep.
And if important point here on the third bullet point on your slide, that if we are dealing with one of the many whistleblowing interim relief applications, but one of the things the claimant's going to have to do is obviously identify what the protected disclosures are. They have to do that at the interim relief hearing, and they're going to have to satisfy the employment judge that their putative or alleged protected disclosures are in fact likely to be capable of amounting to protected disclosures under the ERA. I think the last bullet point there is something we've already touched upon, but if other matters such as employee status or illegality of contract are in dispute, then they also have to be established, and it's the same high standard as applies to the application generally. Is it a winner?
You made an interesting point about the sort of the burden on the respondent if they lose this, and they have to potentially pay the claimant's salary into the future or give them their job back. One thing that you don't find in the statute is any way of getting that back. So where you mentioned injunctions, you've generally got a cross undertaking and damages with an injunction. There's no mechanism of that sort with interim relief. So if you're having to pay the claimant for a period of time until the final hearing, if you get to the final hearing and the claimant loses and you're finally successful, you're not going to get that money back. It's gone. There's no mechanism for recovering it. And so it is potentially very onerous on the respondent, which all goes to what Sam's been saying about the high test. And probably that will lead to people wanting to settle the claim if the claimant has won, because these days we've got a long wait, haven't we, for most final hearings. So it's a pretty tough one for the respondent if you lose an interim relief claim. We'll come on more to the remedy in a minute. Where have we got to? Burden on the claim. Yes.
Looking at the respondent's role now.
Yes.
So we've looked a bit on what the claimant has to prove and the sort of hoops that they have to jump through. Well, what's the respondent going to have to do when this application lands on their desk? We've got a few bullet points here. So you may not have much more than 7 days notice of the hearing. You do have to be given 7 days notice, and if you haven't got that, then that will be a ground for the tribunal adjourning the hearing. But it is quite a restrictive power that the tribunal has to postpone a interim relief application. Yes, there is that minimum requirement of notice of 7 days for respondent, but other than that, it should really stay in the list, as it were. And it's very hard to postpone these applications. So what the respondent going to do in this situation? Well, bear in mind that the real focus of the tribunal is going to be upon why was this claimant dismissed, and is it the prohibited reason? So if at all possible, you want to be obtaining a witness statement from the dismissing officer, which focuses on the reason for dismissal. So in their own words, explaining what it was that led to Joe Bloggs being dismissed. So it wasn't anything to do with the whistleblowing. It was because we'd had a misconduct investigation, for example, and we were satisfied that the claimant was guilty of misconduct. So you want that straight from the horse's mouth, straight from the dismissing officer, explaining the reason for dismissal. And you want, if at all possible, to attach to that a bundle of documents showing those things that should persuade the tribunal that that was the genuine reason for dismissal. So the investigation notes, the invite to the disciplinary, etc., etc. As we said, at the very least, try and put, if you can't get the statement in, of course, there may be situations where you've got so little time to act, you may not be able to trace down the dismissal officer. They might be on holiday, for instance. But if you haven't got him or them available, then at least get the documents which prove that they did approach this in a straightforward and above board manner, and they weren't just trying to get rid of a claimant for a prohibited reason. So you want dismissal meeting notes, etc. You don't need to put the ET3, and it's sometimes a good idea if you've got the opportunity and the time to put in a draft grounds of resistance at the actual interim relief hearing, but there's no obligation to do so. And in fact, you may not even have the detail from the claimant as to what their whole claim is yet, because I think there's a provision in the the ET1 form, where the claimant can actually say, well, I'm applying for interim relief and I've not provided my grounds of complaint.
Well, that's it. Yes, because of the short deadline, they generally put in the interim relief application, and that's obviously related to the alleged dismissal or reason for the dismissal. But they may have a whole host of other claims that haven't been pleaded yet, and so it may not. There's not really any point putting in an ET3 in any great detail until you've got their full claim, and you'll have a notice from the tribunal giving you a deadline for that provision of the ET3 in the usual way. So what happened at the interim relief hearing? Well, I quite like an interim relief hearing because they're quick and dirty and they're quite good fun. I appreciate for the parties involved, fun may not be the word on their mind, but they're slightly more brisk than the typical hearings can be. They're usually just given half a day. Almost never do you have witness evidence. The Rule 94 of the tribunal procedure rules suggests that you shouldn't have oral evidence unless the judge decides otherwise. Generally, the judge doesn't decide otherwise, and you just have submissions. And I suppose you could ask to cross-examine the other side, but probably not very advisable. It might just give them the opportunity to improve their case. So tend not to go down that route. Focus on submissions. And if you're for the respondent, that's the fair reason for the dismissal. And if you're for the claimant, obviously that's why you say you were dismissed for a prohibited reason. Don't get distracted by other issues that may or may not arise. Just focus on the reason for the dismissal. And the tribunal is going to have limited documents. They're not going to have the full bundle that they may have in due course. They're not going to hear from other witnesses or even from the claimant, most likely. So they're going to be doing a sort of broad brush analysis. What does it look like on an expeditious summary assessment is one of the quotes from the case law. It's quick and dirty, in other words. So there's not much time to get into the nitty gritty of it. You can see how difficult it is for the claimant to succeed because you're not going into the nitty gritty. There's relatively little evidence before the tribunal, but yet you've got to persuade the tribunal to a very high standard, as Sam's explained, that you're going to succeed as the claimant at the final hearing. So you can see there are difficulties all along the way for the claimant. And as we say, that's really because there's such a high burden on the respondent if the claimant succeeds. It's only going to be in the very starkest cases that the claimant will succeed and the respondent faced with that burden. Judges at the interim relief hearing, because they've had this initial hearing on the merits, essentially, are not allowed to conduct the final hearing. That's not actually in the statute, but that's what case law says, and it's obviously sensible, and I'm sure that will be that would be the way forward. And something else that must not happen at the interim relief hearing is the judge is not allowed to make findings of fact that will bind the hands of the final tribunal hearing the final matter. And again, that obviously makes sense because at this early stage, you may not have the full picture. So it is sort of quick and dirty, essentially.
You will get quite a sort of summary approach from the judge. It'll be a judge sitting alone. You won't have wing members. Obviously, they're a bit of a dying breed in all aspects of the employment tribunal, but you're certainly not going to get them in an interim relief application. You're likely to get your decision at the hearing. They're not going to reserve it. Almost definitely not. And they'll give pretty brief reasons. As Kath says, they're not going to make findings of fact about, well, I think it's more likely than not that this happened. They're just going to take a step back and say, well, I've heard the evidence, I've read the submissions, and it is helpful if you can do a skeleton argument, just setting out the statutory framework, whether that's from the claimant's perspective or the respondent's perspective. Judges like to say, I've heard read the documents, taken time to read that, I've heard the submissions. My gut instinct is that this is a case which is likely to succeed for these reasons, give some bullet points, but that's all you're going to get. Now, you might well get a written sort of account or reasons given by the tribunal subsequently with the case management incorporated. Now, as Kath said, the judge who hears the interim relief application will not hear the final hearing months down the line, but bear in mind that there will be a record of their thinking at the interim relief hearing on the tribunal file, and may well have been given to the parties in the reasons. So that will be available. There's no prohibition on the employment judge at the final hearing having regard to that, albeit no doubt they're meant to put it out of their mind. Right, so let's look at what happens if claimant doing cartwheels wins, respondent head in their hands, they've lost.
Yeah.
What's going to happen in terms of remedies? So the primary remedy is reinstatement or re-engagement. So effectively, what happens at the end of the hearing is the judge says, right, I've decided that the claim is the application is successful for interim relief, and now I need to consider what's to happen next. And they will ask the respondent, are you prepared to reinstate the claimant or re-engagement in a different role pending the final hearing? Now, you're going to quite often get a respondent who may well say, because they've discussed it with their client, that, look, we don't really want this individual back in the workplace. And in those circumstances, they do have the power to say, well, we're not prepared to reinstate or re-engage the claimant. That's perfectly acceptable. And the tribunal makes what is called a continuation order. Now, you might think, well, that's a rather unusual approach for an employer to take, because a continuation order is you get all the pay and the benefits of work without actually having to come into work.
It's the dream, really, isn't it?
The dream scenario, perhaps, for a judge. Although not if you're a
not if you're a respondent.
Yeah, and also perhaps not if you're a trade union official that wants to be doing his job. But anyway, there you go. But I see what you mean. You do get effectively you're put on sort of almost garden leave, or a type of garden leave.
Exactly.
So you might think, well, why would the respondent say, that we're happy to have a continuation order rather than actually reinstate the claimant? Well, it might be purely because the sort of fallout of getting this individual back to the workplace is likely to be so extensive and disruptive that the employer is prepared to take the hit, as it were, in terms of paying them without actually getting them back and causing problems. Nothing wrong with that. That's permitted under the legislation.
Yeah, but sorry to interrupt. It may prompt settlement talks, though, mightn't it?
Yeah, I mean, if you are paying, I mean, you're paying this employee. If you've lost your interim relief application, then that might give you a bit of a feeling for the way it's going to go at the final hearing, because one judge has already looked at it and thought, right, there's something in this. You might have an uphill struggle in terms of persuading another judge, albeit the evidence will be wider. I think experience tells you that if you've lost at the interim relief application, at interim relief stage, you're well advised to consider whether there is some kind of settlement possible.
Well, plus if you don't settle, they're going to keep picking up their salary for potentially years now, because we all know how backlogged the tribunals are. So it can be really quite expensive for the respondent, presumably, if they don't do a deal.
That's right, Kathy. It can really sort of keeps ticking, as it were, the clock, and it in terms of effectively compensation or remuneration to the claimant until you get actually back to the tribunal for your final hearing. Just a couple of the bullet points on this slide you've got there. It might happen that the respondent just doesn't attend the interim relief hearing. Say it's a small employer that hasn't engaged in the process, or maybe hasn't been given notice of it, then the tribunal would make a continuation of the contract order. So that would happen automatically. Obviously, it emphasises the fact that if you're the respondent, you should attend. And the final point, which I think we have mentioned, is that this is a real there's a real onerous burden on the respondent, because if you lose your interim relief application, you have to either reinstate them or pay them under a continuation order. And this is the rub, that even if you win the substantive hearing, so you persuade the tribunal that the dismissal had nothing to do with whistleblowing, nothing to do with trade union detriment, and everyone's happy on the respondent's side, well, not quite, because you haven't got any way of recouping the money you've paid the claimant in the interim. There's no power under either the ERA or Ultorica to sort of reclaim, if you're a successful respondent, to reclaim what you've paid the claimant.
I think the one thing you might be able to do is if you, for example, you discover that the claimant's taking the salary from you under the continuation of contract order, but they've gone off and got another job, and so they're getting a salary from that as well. Those are the sort of circumstances where you might make an application to vary or even revoke the order, because they're getting double the money, and the tribunal might take the view that that's no longer appropriate then to the respondent to be paying them up to the final hearing.
Yeah.
So, but whether you'll find that out, I mean, the claimant may not be telling you about that, but
Sometimes it does happen that obviously because a claimant is free agent, they're not going into work, so they could quite possibly be thinking, well, I'm on a winner here, I get paid and I can also get another job.
yes.
The other thing just to mention here is that sometimes you might get an employer that doesn't comply with the order for reinstatement or re-engagement made by the tribunal. I mean, I think it's quite rare, because if you're going to adopt that approach as an employer, you're better saying, well, we'll have a continuation of the contract rather than reinstate or re-engage. But if you don't have that foresight and you walk out of the interim relief hearing with a reinstatement order and you fail to comply with it, then the employee can come back for an order for continuation of the contract and compensation then. So you can't just kind of ignore it, as it were.
Yeah.
So that's a quick whistle-stop tour through the legislation and what has to be proved and what you need to focus on. And we've now got some tips.
Yes. Tips for claimants and tips for respondents. Well, this is a sort of summary of some of the things we've already discussed, so we can quickly whiz through these. In terms of tips for claimants, obviously you can't hang around. You've got 7 days, and you can use this as a tactic to try and pressure the respondent to settle. Even if you're not successful, even in that first week, you never know. You might be able to do a deal, because the threat of an interim relief award may be something that prompts the respondent to settle, or at least start thinking about that. You're going to have to be very analytical if you're the claimant, going through every element of the claim that you're seeking to bring. So as Sam was mentioning, so with a whistleblowing claim, what's the disclosure? Does it go to one of the 6 things in section 43B of the ERA? Did you have a reasonable belief it was in the public interest, and all of those things? All of those need to be addressed. There's no good saying, oh, I'm a whistleblower and that's the end of it. So put in a statement, signed witness statement, explaining why you say you were dismissed for the prohibited reason, and then have a think about how the respondent will try and fight that. What's the respondent going to be saying in response to you? They're going to say, oh, wasn't this gross misconduct reason? Well, as the claimant, you might want to say, well, that was a sham reason for these reasons. So those are the sort of key things for the claimant to be thinking about. Yeah,
you might want to chip away a bit at what you think the respondent's going to say. So if you know the respondent's going to be relying upon conduct, it's unlikely you're going to have a respondent that's not going to come up with some reason as to why they say the dismissal occurred. So if you can anticipate that they're going to rely on conduct, then you might want to do some digging and sort of some work on disproving that was the genuine reason. In other words, that it was a bit of as Kath said, a sham that's been sort of dreamt up.
Yeah.
So for the respondent on the flip side, as it were, let's just remind ourselves of some of the things that the respondent's going to have to focus on. So check that the claimant has complied with the formalities of the application for getting it in within the required time limit. That it's not they haven't sort of put it in sort of several weeks later.
And that it's not just for ordinary unfair dismissal, or one of the reasons you can't bring a claim, especially if they're litigants in person, they might not have understood the gateway provisions.
Yeah, make sure, look at the either the 96 or 92 Act to make sure that this is actually one of the dismissal situations which is covered by the gateway provisions, and ensure that they've that you as a respondent, as a procedural point, has been given at least 7 days notice of the hearing. If you haven't been given that, then the tribunal should postpone it themselves, but if not, then you should be able to prompt the tribunal to do so before the hearing. Put in, as we said, some evidence focusing on what you say was a fair reason for dismissal. And if you've got evidence that the claimant doesn't meet the other requirements for an interim relief application, so that you think, well, they're not an employee, and I can point to an agency contract which makes clear they're a worker, then you would be well advised to put that in before the judge at the interim relief application hearing. because that will be one of the sort of preconditions which the claimant won't be able to satisfy the judge of. But then you do need to be alive to the fact that if interim relief is awarded, then you want to be ready to get on with the case as quick as possible. You'll have obviously the opportunity to put your ET3 in, and the tribunal should be alive to this, that the final hearing needs to be listed as soon as possible.
Mm-hmm.
And the last point there, as I think we mentioned a few moments ago, most important rule of all for respondents is actually to turn up to the hearing, because if you're not there, then the tribunal will make an award in the claimant's favour, and you'll be stuck with that until you get to a final hearing or unless you settle the case.
Or there may be situations where you can apply for it to be overturned if there's a good reason you weren't sent the details.
Yeah.
For example, the claimant gave the wrong address or something like that.
Yeah,
But,
I mean, it's not impossible that
No.
you get respondents that aren't served with it by
Yeah.
the tribunal, and that would be a situation where you could, you'd probably get a reconsideration of the
get it
interim
overturned or
relief
whatever. Yeah.
award.
Okay. So Sam, do we have any questions?
Well, let me see, Kath.
Yeah.
We've got any
Yes, I don't know if any of you lovely listeners have sent in any questions for you. Are there any there that we can help with?
There don't seem to be any at the moment. So obviously we've answered all the things that you were
We've
dying
covered
to
everything
ask us,
that you wanted to know about interim relief.
which is an excellent result for all concerned.
Good. So, well, yeah, we've dealt with interim relief in what, 45 minutes.
We've
So
done it in a quick and dirty fashion.
quick and dirty about a quick and dirty subject. So
Yep, so that's very good.
if any questions occur to you later, you've got the email address. Well, we can remind you of it. I think you've got a few points just to scoop up, Sam, before we say
Yes.
good evening.
Thank you all for attending. As Kath mentioned, if you have any unanswered questions, we can follow them up by an email. A reminder that if you are watching the recording and have any questions, email them through to events@fortitudebr.com. The recording will be available on the website and our YouTube channel shortly. And as ever, we'll be very grateful for any feedback you might have about the format of the presentation, the slides, etc. Whether you like Kath's glasses or not.
Oh, thank you. I thought you'd never mention.
I've meant finally, that's the most important point to mention. And the next session in the series will be a trial, and the next session is entitled Trial and No Errors, Top Tips for Helping Your Barrister and Clients Succeed at Tribunal. And that's going to be hosted by our colleagues Nick Singer and Jamie Fireman.
Yeah.
That's on the Tuesday, the 7th of October.
Sounds like one to catch.
I've got one now, just as we thought we were
We have a
finishing,
question.
a question has popped up.
Good. What's that?
How do you, I might give this to Kath perhaps, how do you submit the application? Can it be done on the portal?
Oh, that is a good question because I've never done one, not being a solicitor, but I think you can, because if you've envisaged the ET1 claim form, there is a box, and I think it's 2.3 that you tick to say you haven't done ACAS conciliation because you're bringing a claim for interim relief, which says to me, yes, you would put in an ET1 in the usual way, obviously within 7 days. And certainly all the interim relief applications that I've done, there's been an ET1 from the claimant and indeed particulars of claim either within that form or as a separate document in the usual way.
Yeah, I'm pretty sure I'd be very surprised if it can't be done on the portal, because that's the sort of the.
Yeah, in fact, I don't know how else it will be done, to be fair. So yeah,
I'm not sure they're going to accept paper application anymore.
No, I don't think so, not anymore. But so ET1 in the usual way. But you may, of course, as a claimant representative, you may end up doing another ET1 in due course with the rest of the claim once the interim relief matter's been dealt with.
So thank you for that question. And as I say, any more than just pop over an email and we'll get back.
That's it for today, is it? No more questions there?
That is for now, I'm afraid. Yep.
Okay, no, that's fine.
So that concludes the webinar. Thank you again for attending, and we look forward to seeing you at our future webinars.
Thank you very much and good afternoon.